And in cause number 250514, Mr. Franklin's charged with aggravated robbery. Mr. Lewis, what is the announcement?
Well, Judge, Mr. Franklin, I understand that the complainant witness had been in touch with the state on this one.
Judge, may I put a few things on the record, please?
Yes, ma'am, of course.
First, may I have the name Kayla Davis called?
Would you call the name Kayla Davis, please?
Well, pause right there. Kayla Davis is about to testify against her own husband. Or is she? This isn't just courtroom drama, it's a legal landmine. Aggravated robbery involving your spouse and kids. Buckle up, this one's got layers.
Good morning, ma'am. Are you Kayla Davis? Ms. Malfino, do you need some time maybe to visit with her, or do you want to go ahead and put something on the record?
Judge, if you
Okay.
just want to swear your...
Ms. Davis, would you please raise your right hand? Do you swear or affirm the testimony you'll give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. Thank you. Go ahead.
Ms. Davis, would you please state your full name for the record?
It's Kayla Davis.
And Ms. Davis, what is your relationship to the defendant, Justin Franklin?
He's my husband.
Okay, and how long have you all been married?
We got married in January.
In January? And you know what we're here about today, right?
Yes.
The aggravated robbery that he's alleged to have committed against you and your children, right?
Yes.
Where he held you all at gunpoint and stole your purse and wallet, right?
He didn't tell us in gunpoint, and he didn't steal my purse nor wallet.
Did you tell the police that that's what happened?
No, ma'am.
Okay. So if that's what the offense material reflects, and that's what the grand jury proceeded on with an indictment for aggravated robbery, are you saying under oath to the court today that that did not happen?
Yes.
And you have many times called my office asking that the case be dropped, correct?
Yes.
You've come.
Let's unpack this. The prosecutor's throwing in the towel, but not before putting it all on the record. Why? Because if something happens to Kayla in the future, this transcript becomes evidence. Smart move. And a chilling reminder that not every dismissal is the end of the story.
Been and signed a non-prosecution affidavit.
Yes, I have.
You have called saying that this did not happen and that you're not going to cooperate with the state, correct?
Yes, I have.
Are you in fear of Mr. Franklin?
No, I'm not.
Is he pressuring you to do this?
No.
And do you understand that if the state does not proceed with this case, that you're taking matters into your own hands?
Yes, I do.
With respect to your safety?
Yes, I do.
And that's what you want me to do?
Yes, drop the case, please.
And you're asking Judge
I'm
West
asking
to allow
Judge
me
West
to drop the case?
Drop the case.
All right. All right, you can step back.
Thank you. And Judge, just for the record, if I may, obviously with those facts, obviously the court is aware of experiences you and I both had in the past. I think there was something more to the incident. She's obviously not going to cooperate with me. She's obviously also his spouse. And so at this time, with the court's permission, I would move to dismiss, but I just wanted to be sure all of that was on the record so that if something were to happen in the future, everybody is aware that those were specifically her wishes.
All right.
Let's unpack this. The prosecutor's throwing in the towel, but not before putting it all on the record. Why? Because if something happens to Kayla in the future, this transcript becomes evidence. Smart move. And a chilling reminder that not every dismissal is the end of the story.
If that comes through based on all of that, I don't know how you can do anything else, and so I'll sign that. Mr. Franklin, I'm not sure what, if anything, happened. My thought is something did happen. Hang on, just let me talk, okay? Don't talk yourself out of this, because here's what can happen. It's not easy, but it is possible to go forward with cases without the complaining witness. So whatever happened needs to not happen again. You need to get a grip on whatever anger, whatever issues you have. If you've got someone here that cares about you and you want to be a part of their life, that's not what you do to people that you love. And it's definitely not what you do where there are children involved. Do you understand? All right, go back with the bailiff.
Thank you.
Yes, ma'am. Good morning, sir. Are you Jack Hooper?
Yes, Your Honor.
And in cause number 17-27896, Mr. Hooper is on probation for driving while intoxicated, third or more. There was a motion to revoke filed. We were previously here. Entered pleas of true to counts 1 through 6. I've received an updated pre-sentence report, and the agreement was for a cap of 4 years. Is that correct?
That's correct, Judge. He's indicated to the probation officer, indicated to me that he would rather not be put back on probation. He's asking to be sentenced to 3 years. he doesn't have, well, I mean, he doesn't have any new cases as violations or the possession, testing positive. He seemed to report to the probation department and did everything he did. The problem was he had an issue with marijuana. We're asking that, I think he should be given some consideration for that. We're asking for a 3-year sentence.
So you stopped reporting May 5th of 2021. So didn't really report as
I apologize.
directed.
I misspoke that.
You've been an absconder since 2021. Ms. Malfino?
Okay, let's talk about Jack Hooper, the ghost of probation past. My guy dipped in 2021 and shows up now asking for leniency like he's been a model citizen. Spoiler alert, probation doesn't work if you vanish for 4 years. This judge not buying it.
Judge, I think the consideration that he was given was with the cap of 4 years. I completely understand if based on the original PSI and his history and his attitude, the court does not think that that is an appropriate amount, but I would obviously recommend revocation, whatever amount you think is appropriate if we need to revisit that issue.
What happened with the Sabine County DWI back in 2017 at the same time as this one?
They dropped it.
Okay, at this time I'm going to find that you entered your pleas of true to counts 1 through 6. Find those counts true. Ms. Malfino is exactly right. You're lucky that you made a plea agreement for 4 years, because I'm not really sure that not showing up since 2021 and just saying I want to take my time and be done with it is the kind of attitude that I appreciate. But I'm going to find sufficient evidence at this time to revoke your probation, and at this time revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you have waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Jeremiah Johnson.
Okay, maybe.
You see what I'm saying? At
Yeah,
the top.
it wasn't one of the allegations. That's why I was looking at the wrong thing.
Because the motion was filed way back then, I guess.
Right.
So that's why it hadn't been. Good morning. Are you Jeremiah Johnson?
Yes, ma'am.
And Mr. Johnson was previously here in cause number 250330, entered a plea of guilty to aggravated robbery, and 250331 also pled guilty to aggravated robbery. Cause number 250408 and 0409 pled guilty to theft of a firearm. The agreement on these were for a 10-year deferred on those 2 aggravated robberies and a 2-year term probated for 5 years on the theft of firearm cases. I've received the pre-sentence report. Has everyone had an opportunity to review these reports?
I haven't.
Or the report? Are there any additions or corrections? So, I don't know about all this. Not real sure I want to go along with this plea agreement. Mr. Johnson,
Yes, ma'am. I promise that I'll do right this time.
this time,
Yes, ma'am.
you have been in trouble for breaking into people's cars,
I promise I'll do right this time. Classic courtroom comeback. But this isn't Jeremiah's first rodeo, or second, or third. The judge is clearly skeptical, and for good reason. Stealing firearms. Shooting at people, sir. This ain't summer camp. This is your last chance.
stealing guns, shooting at people over and over and over again.
Yes, ma'am. God can show me that this is not nothing I want to do in life.
When did he show you that?
Being in jail, incarcerated.
You've been in jail before. You didn't find God when you were there before?
Yes, ma'am. I'm not making no excuses.
Here's the thing, I hope you have.
Yes, ma'am.
I hope that you have found him. The problem is, you lose them when you get out of jail.
Yes, ma'am.
And that's what a lot of people do, is when you're looking at time and you're incarcerated, you're like, oh, I don't want to do this. And then you get out and you go start doing the same thing because you think you're cool and you're going to go steal guns and you're going to shoot at people when you're lucky you're not here for murder.
Yes, ma'am. I gotta be here for my little girl. I can't mess up no more. I'm afford to.
You're how old?
28.
You're 28.
Yes, ma'am.
You're way older than old enough to know better. You know, this is something I see a lot of times with these 15, 16, 17, 18-year-old kids. Your child's 7 years old,
Yes, ma'am.
so it's not like you have a baby and all of a sudden you know you need to be there for her.
Yes, ma'am. I know. I made a few mistakes in my life, but I'm willing to try to.
That's an understatement, don't you think?
Yes, ma'am. I understand.
I appreciate too that you're being honest with me today, but I have to look out for the community as much as, you know, I kind of have two things I've got to do here: figure out what's best for you, but also what's best for our community.
Yes, ma'am.
Your Honor, I will say when I first met with him that, I mean, early on, he's just said, I'm tired of this life, you know, I don't know why I'm doing this and I need to get my stuff together. And
Yes.
do you have, I understand exactly what the court says. Everybody finds God and, I mean, Jesus in jail, you know, but sometimes I think there's some truth that when you're sitting there and it opens your eyes that, you know, you do realize that I'm getting too old for this. I'm just ready to settle down and do what's right. And he seemed to have that attitude when I first talked to him.
Yes, I mean, I just ask if you give me one chance, just one chance to prove myself.
So I want to make sure, and we're going to go over this. If you get this chance and you violate it,
Yes, ma'am.
you got the rest of your life that I can give you in prison.
Yes, ma'am.
And when I have to spend some time and it bothers me, a lot of times I don't remember. People say, oh yeah, you remember when you put me on probation? I don't. I'll probably remember you.
Yes, ma'am.
Especially because you put things on your face so people can remember you by them. Probably not the smartest thing either, right?
No, ma'am.
Okay. Any reason not to go forward with sentencing, Mr. Smith? All right, so here's what I'm going to do, Mr. Johnson, because of my concerns.
Yes, ma'am.
I'm going to give you an opportunity, but I'm going to hopefully give you some tools to be successful.
Yes, ma'am.
I'm going to find in each of your cases that you enter your pleas of guilty freely and voluntarily,
Yes, ma'am.
and find sufficient evidence to find you guilty. In cause number 250330, defer all proceedings, place you on probation for a period of 10 years.
Yes, ma'am.
You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'm going to go through certain conditions in a few minutes. In cause number 250331, find sufficient evidence to find you guilty. However, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years. You will pay a $500 fine in that case as well and follow all of the rules and conditions of probation. In cause number 250408, find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that, you'll be on probation for 5 years in that case. You're also ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Cause number 250409, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of a firearm. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. And you're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation. One of the conditions of your probation in each of your cases is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program, so you're not getting out today. But I'm doing this to continue you hopefully making the better decisions. This program is all about making better decisions. Staying away from the people that you need to stay away from. If you really want to change your life, you can. People do it. It's not easy sometimes, but you're going to be given the tools. And if you don't, then you're back here, okay? And so here's something that's very important though. You have a handful of write-ups in our jail. I see those. I'm going to see if you have any more between now and when you go to ISF. It will be a violation of your probation if you have more incident reports in our jail or if you have any in ISF. So if you are disrespectful to those officers that are just out there doing their job, if you're fighting, if you don't button your jumper up because you're too...
Mic drop moment. The judge just laid down the law. You violate probation. You're looking at life. This isn't fear-mongering. This is Texas justice. And with 4 different cases on the line, Jeremiah is walking a legal tightrope with no safety net.
Cool to button your jumper up. Just follow the rules. When you're out and you're not in custody, you can make whatever decisions you want. When you are in custody, you're going to follow those rules. If you don't, again, that's part of your probation now, is that you follow all of those rules and don't get in trouble. You could be back in here on a motion to revoke your probation before you ever hit the streets again. So whatever's going on in the jail, you better go in and say, whoever else is messing around, get on your bunk, do what you're supposed to, get to ISF, get out, do what you say you're going to do, okay?
You said how long ISF?
It's a 90-day program, okay? So you've got 2 separate things going here. Now you've got the deferred probation on those aggravated robberies, which means at this time you don't have a conviction on those cases. That's a great thing for you. It also leaves it open though. If you violate any condition of your probation, you're back in here. I can convict you of those offenses and you could be sentenced to anywhere in the range of punishment, which is between 5 years and up to the rest of your life in prison, the whole range of punishment. Also, if you violate on those theft of a firearm cases, you've already agreed in those to the maximum punishment, which is 2 years in the state jail prison. So if you violate, you've already agreed to those 2 years. Do you understand? Okay, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Not just any charges, more felony charges. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you can, or how long that lasts, you can talk to Mr. Parker. All right? Good luck. Take advantage of this opportunity.